Item number 1.
None appears dismissal, no prosecution.
Item number 2.
My lord, it is already complied, my lord. Compliance
All
affidavit
right.
has been filed.
All right. Counsel for the petitioner points out that the petition has been rendered defectuous to dispose of this.
Weekly list item number 3.
Item 3 minutes, I am for the opposite party with BDA minutes.
All right. None appears.
That was
None appears for the petitioner. Dismissal, no prosecution.
Weekly list item number 4.
None appears. Dismissal, no prosecution.
Weekly list item number 5.
May I please, please. So I have three very humble submissions for
Yes, yes.
Lordship's Lord. The first one is that the audit visit report was not submitted within 7 days as stipulated under section 41(4) and read with rule 45(3) minutes. The second, my lord, is forcible collection of tax, a penalty, my lord, by the audit visiting authority which has been deprecated by this honorable court without affording a chance of hearing to me as stipulated under section 73(10) minutes. Third, my lord, the petitioner being a tin dealer, the judgment of these honorable courts said, my lord, he should have been assessed by the ACCT of the range, not of the circle, my lord. So for the first,
These are two petitions, the same facts. Is it?
my lord, same facts.
Okay.
My lord, may I just place the audit visit report, which is at Annexure 2, page 19, my lords, and the relevant portion. I'm sorry, my lords. If your lordship would kindly turn to page 21, my lords.
Yes.
Your lordship got it?
Yes.
It's the third paragraph.
Yes.
The place of business of the dealer was visited by the officials of the enforcement squad on 19/7/2006.
Right.
Then they called me on 2/8/2006, my lords.
All right. So that's
Then if
more
your
than,
lordship would turn over the page and come to the end of that annexure at page 23, the audit visit was report, my lords, was approved on 10/8/2006.
Hmm.
Then if your lordship would again come back, my lord, to the annexure 1 at page 19, my lords, the date is not visible, but your lordship would see the stamp at the right hand side, September 2006, my lords.
Right.
So it's more than 7 days. And recently, your lordships have decided in Kanika Furnitures, which is violative of our section 41(4) and
All right.
the second submission, my lord,
No,
would
he's
be-
agreeing to this itself. Then it's. He's not disputing this.
My lords.
We need not go into the other points.
No, because the second might be important because your lordships are directed for refund of the tax collected, penalty collected, I'm sorry, by the audit officials on the date of audit visit itself without passing any show cause notice
All
or
right.
without giving me a chance of hearing.
Where is
Your
the
lordship-
judgment? You said it's been deprecated.
My lords,
So the penalty amounts has to be asked to be refunded.
my lords.
All right.
That your lordship would get it. That's MG Garments. That's
Right.
reported in 2009-19 VST page 372 minutes.
Right.
Sure. I'm sorry.
Right. So you see, there are two grounds on which
Let's
these petitioners have approached the court, put both the petitions, seeking reliefs against the sales tax department, bracket department. One is that the audit visit report was not submitted within 7 days of the visit. And the second is that, contrary to the decision of this court in MG Garments versus Sales Tax Officer Investigation Unit, 2009-19 BST 372 bracket Orissa bracket, penalty amounts were collected by the audit visit team at the time of the visit itself without any previous show cause notice to the petitioners. Paragraph. As far as the first issue is concerned, it is seen from the copy of the audit visit report form that the visit in fact took place on 19th July 2008, whereas the report itself appears to have been prepared only on 10th August 2006 and submitted much later, sometime in September 2006. Clearly, therefore, the audit visit report is beyond the mandatory period of 7 days. Where is that judgment of ours?
Kanika minutes. Sorry.
Recently, this court, in its order dated 10th May 2022, in Writ Petition Civil 7753 of 2010, bracket Messrs. Kanika Furniture Private Limited, Baleshwar versus Joint Commissioner of Commercial Taxes, Baleshwar, had in similar circumstances where the audit visit report was not submitted within 7 days of the visit of the audit visit team. It was held to be in violation of Section 41 bracket 4 of the OVAT Act, read with Rule 45 bracket 3 of the OVAT rules. Consequently, the audit visit reports in both these cases are hereby quashed, and all consequential proceedings thereto are also hereby quashed. Paragraph. As regards the penalty collected from the petitioners, admittedly, this was without any prior show cause notice, and it was at the time of the audit visit.
My lord, as regards the refund that forcibly collected, I believe there is no such averment in the in the petition to that effect.
Your Lordship,
And yes, at the time of place, on the date of visit, the owner of the
He
farm,
volunteered, you'll say.
but there is no averment to that effect.
MG Garments, my lord, exactly, your lordships have dealt with that submission of the revenue, which says that it was voluntary payment. We have not said it, my lord. If your lordship would kindly take, my lord,
Since the writ application,
Okay,
it has to be
paragraph
averred,
5
my lord.
minutes.
It has to be pleaded.
paragraph 5 minutes. Learned paragraph 4 and 5 minutes. Thereafter, the petitioner opted to pay the amount. That was the similar objection, and was taken
As
by.
regards the penalty amount, in MG Garments, Supra, this court observed as under take whole of para 16. Consequently, the court directs that the penalty amounts collected from the respective petitioners be refunded to them within 4 weeks in accordance with the rules, together with interest that is payable in terms of the rules.
Both under 61.5 and 73.10. That's Annexure 1 series at page 17 minutes.
Right.
Under section 61.5 and 73.10 minutes.
All right.
Okay. The lordship, the second part will be only 73.10 minutes. So far as the penalty is concerned, the second sub-item minutes.
All right. All right. Penalty collected under section 73 bracket 10 of the OVAT Act be refunded.
And the dates are almost similar in both the cases.
All right. All right.
Greatly
Both
obliged.
petitions are accordingly allowed.
Greatly obliged.
All right.
I have a pattern to mention, my lord. Item 2, my lord, no instruction, my lord.
All right. 2, no instructions dismissed. Okay.
Weekly list item number 6.
Item number 6, 7, 8, 9, and 10. After the full bench judgment passed by this honorable court in Monisha Enterprises, it is now in favor of a revenue matter. So
All right. Just give us a citation.
that is reported. I don't know the OJC number 13383 of 99.
Judgment date, sir.
20th February 2015.
In view of the judgment dated 20th February 2015 in OJC number
13383 of 1999.
1999.
9.
One in OJC 13383 of 1999 bracket
Monisha
Manisha Enterprises versus
State of Orissa and others.
State of Orissa. The questions urged in the present revision petitions are decided in favor of the department and against the SSC. The revision petitions are disposed of in the above terms. 6 to 10.
That's right.
Weekly list item 11.
Despite 15 years having elapsed, no steps have been taken for seeking continuation of delay. The petitions are accordingly dismissed.
Weekly list item 12.
None appears dismissed, not passed.
Weekly list item number 13.
May I please, Your Lordship? Your Lordship, this is a case where the farmers are not being helped by picking their paddy in time because there was an
Sir,
illegal
what is this item you are arguing?
13
What is the item number? What is the case number?
10238.
No, sir. We are in the weekly list.
Weekly list. Weekly list item 13.
Extremely, sir.
None appears dismissed, not passed.
Weekly list item number 14.
None appears dismissed, not passed.
Weekly list item number 15.
The defects were there.
Defects have not been cured. You say requisites for notice have not been filed for over 15 years. Dismissal non-prosecution.
Weekly list item number 16.
None appears. Dismissal non-prosecution.
Weekly list item number 17.
17, my lord, 42,000 is the tax effect.
All right. In view of the insignificant tax effect, the question of law is left open and the petition is disposed of.
Weekly list item number 18.
Again, I am appearing for the opposite party. They are the appellant.
Here, my lord, the opposite party is under liquidation now.
Opposite party?
Then it has to go to the NCLT.
It is
Sir.
under liquidation.
It is
Let's,
stated that the opposite party is under liquidation. The matter should be before the NCLT. Consequently, the petition is disposed of with permission to the parties to move the NCLT into accordance with law.
May I say something, my lords? The losses kind permission, my lords. They are in appeal against the order of the tribunal. They have lost in first appellate authority and also before the
No, if it is in liquidation, sir, we can't deal with the matter. That's all. Right.
Weekly list item 19.
Lord, 2,782 is the tax effect.
All right. Tax effect being minimal.
I'm appearing for the opposite party.
All right. The court is not inclined to interfere. Leaving the question of law open, the petition is disposed of.
Weekly list item 20.
That's this case. I am submitting today a compilation of a number of judgments because the matter related to whether state has power to levy tax. It's in respect of the papers and chemicals, those which are used for printing the photos by a photograph studio. That's the precise question. Now the time has come because several judgments are there in my favor earlier. Now the position of law is changed because in taxation laws, let me share with my lords. Getting a interim direction may sometimes prove to be a bitter pill because had it been disposed of 5 years before, the judgment, the outcome may have been otherwise. Because now your lordship have to independently look into the judgments, my lords.
Right.
And some judgments are there by other high court because your lordship, I want that your lordship also should see the latest judgment, including other high courts, my lords.
All right.
Because there are also some 4 or 5 STREVs, which your lordship, which I find from the order sheet in my record, in 6/8/2008, your lordship have asked to tag along STREV 112, 113, 114, 115 of 2008. Two types of cases are there, but those are to be analysis taken up here. One case is where the photograph studio not tagged along. So my order sheet says that call this matter along with similar matter, STRE matter bearing STRE number 6/8/2008 order.
You see,
and your lordship have also said I have given a copy of judgment in Sujata photo studio. Your lordship have directed my friend to examine whether the judgment is applicable to the case or not. These two orders are there.
Commissioner says that.
I have also given all the judgment because those who are against me, those who are my favor, all the compendium of judgments I have given to my friend also.
I'll go through the judgments and let all these matters be tagged, my lord.
All right. The compilation of judgments has been handed over by Sri Jagabandu Sahu, learned senior counsel to petitioner, to counsel for the state, additional standing counsel for the department, including a note on the facts of the case.
There's one memo I have filed. Question number 2 is required to be modified because I have said whether that rainbow color laboratory may be read as Studio Sujata versus Commission of Sales Tax 2008, 106, 317. Only to this extent.
But no questions have been framed yet.
No question framed yet. Your lordship have only directed to take instruction whether the judgment which I have referred to, relied upon, is applicable to the present case or not. That with that direction, your lordship the other day, the last 2008.
I think can say admit the following questions are framed. Take from page 17. In question number 2, you say instead of Rainbow Color Laboratory, you have to say Studio Sujata versus Commission of Sales Tax, 2008, 106 CLT 317. That is this court's decision or Supreme Court?
Yes.
No, no.
Reasonable.
Studio Sujata is this court's decision.
Yes, our High Court, Vilas.
Ah.
Yes.
In view of the judgment of this court in Studio Sujata. List along with STREV numbers 112 to 116 of 2008, 112, 113, 114, 115, 116. 22nd June, after the opening, 22nd June.
22nd June. Vilas.
Weekly list item 21.
There is a delay of 5 years now.
Delay of 5 years is unexplained properly. Consequently, the application for delay is dismissed. The STREV is accordingly dismissed.
Weekly list item 22.
22, my lord, the amount involved is 71,000.
All right. The insignificant tax amount. Same amount.
Weekly list item 23.
My lord, delay is 1877 days.
The delay of 1877 days is not satisfactorily explained. Accordingly, the MC number 141 of 2008 is dismissed. Consequently, the STREV is dismissed.
Weekly list item 24.
24, my lord, 5 years delay.
All right. The delay of 5 years is not satisfactory explained. Accordingly, MC number 145 2008 is dismissed. STREV is accordingly dismissed.
Weekly list item 25.
None appears dismissed, not prosecution. All the both matters.
Weekly list item 26.
None appears dismissed, not prosecution.
Weekly list item 27.
May I please fill notes? The short point, my lord, is the nexus. So far as the enhancement is concerned, my lord, I'd only take your lordships to the part of the tribunal's order at page 39 minutes. It's Annexure 3 is the tribunal's order, beginning at page 36, page 39, paragraph 6 minutes. The total suppression was 66,435 millions. So without the tribunal also says that the ACCT, the first appellate authority, has not quantified it. They have made it to 17 lakhs. And the tribunal, my lord, he has reduced it to 10 lakhs. The total suppression, my lord, would appreciate was 66,435.
Yeah, suppression usually 10 times minimum.
No, they have made it, my lord, from 66 to 10 lakhs, my lord. It was first 17 lakhs. It was first, my lord, equal to my GTO, my lord. That is 79 lakhs by the assessing authority. Reduced to 17 lakhs by the ACCT.
Yeah, it's okay. I think we'll stop it at that.
May I pray, my lord, 50% of all the tribunal has directed, my lord.
Here, my lord, there are materials.
So we'll keep it 10 times, I think. That will make it 6,64,000.
Yes,
You say the challenge in this revision petition is to an order dated 20th May 2008, passed by the Orissa Sales Tax Tribunal, Tribunal.
And the questions of law.
That's right, in essay numbers.
In the tax.
818 of 1999-2000 for the year 95-96. You say, admit the following question is framed for consideration. Whether the tribunal is justified in sustaining the enhancement of the gross turnover bracket GTO by 10 lakhs, whereas the actual suppression worked out to rupees 66,435. Paragraph. The operative portion of the order of the tribunal reaches under para 6, page 39. Paragraph having heard learned counsel of the parties, the court is of the view that the enhancement up to the extent of 10 times the amount of suppression would serve the ends of justice. Accordingly, the enhancement of the GTO is reduced to 664,350. The question is accordingly answered, and the STVs is disposed of in the above terms.
The amount may be refunded, my lords.
Any excess collected from the petitioner,
If collected, my lords,
will be refunded in accordance with the rules. All right.
quickly.
Weekly list item 28.
None appears dismissed from this.
Weekly list item 29.
None appears dismissed from non-prosecution.
Weekly list item 30.
30, 31, 32, all dismissed. 33 also, 34 also.
30, 31, 32. Item 33. Item 34.
Dismissed
Weekly
from non-prosecution. Right.
Weekly list item 35.
May I please your lordship?
Your Lordship, on 17 July 2009 has framed the question of law.
Yes. Whether publication of the notification of the Orissa Gazette can be made effective from the date of its printing or the date
it is made
Has to be
available
from
to
the date of
public.
printing, sir.
My lord, what has happened in the taxation law, my lord, if it will not come to the notice of the public, then if there is an exemption or there is a tax has been levied, then in that circumstances, if it will not come to the notice of the public
Where's the
or
case
it
law
is
on
not
this?
made available to the public,
Show me the case law. Case law is.
pardon, my lord, I have also collected some case laws.
Show us that. There's a judgment of Justice Chinnappa Reddy of the Supreme Court on
There are
this.
two Supreme Court judgments, my lord. One High Court, Madras High Court judgment and one Supreme Court judgment.
No, the Supreme Court, is it by Justice Chinnappa Reddy, the judgment?
No, it is Honorable Justice Nanavati, my lord. At page 33, your lordship ends.
Anyway, there's an earlier judgment, maybe that will be referred to in this. All
My
right.
lord. The date of notification.
Ah,
My lord, if your lordship will come to the para 11, my lord. Para 11 at page 41, my lord. Running page 41.
yes.
We hold that a central excise notification can be said to have been published except when it is provided otherwise, when it is so issued as to make it known to the public. It would be a proper publication if it is published in such a manner that persons can, if they are so interested, acquaint themselves with the contents. If publication is through a gazette, then mere printing of it in the gazette would not be enough, unless the gazette containing the notification is made available to the public. The notification cannot be said to have been duly published. My lord, in this case, my lord, on 26 June 1997, there is a notification where the state government has enhanced the tax rate from 10% to 20% on IMFL, Indian Made Foreign Labor. My lord, we have applied for the gazette notification. If your lordship will come to page 37 of the brief, revision petition.
Yes.
Supply of gazette number certain subject, your lordship kindly mark. So, gazette number 815 dated 16, it is 26 actually, 26/6/1997. The next paragraph is the answer from the publisher, Orissa Gazette. The Gazette asked for in your letter under reference has not yet been published, and as such, it is not possible to supply the same at present. The same will be supplied as soon as it will be published. My lord, then kindly turn to the next page. On the RTA, we have asked for certain information. Please refer to your application dated 20th May 2008, addressed to the undersigned, requesting information on the date of supply of Gazette notification number 815 dated 26 June 1997 to the Finance Department and for public sale. I am to inform you that the above mentioned gazette was received by the government in Finance Department on 28 June 1997 and was received by publication section of this directorate on 5/7/99 for public sale. So it has been made available to the public only on July 1999.
Yes.
So during those periods, whatever the tax, I have collected 10% tax from my customers. I have not collected 20% tax. As an abundant person from 2nd of August, I have collected 20%. But from 26th to 1st of August, I have collected 10%. That is the disputed demand.
26th of June.
26th of June to 1st of July.
1st of July.
1st of July.
Only 5 days.
Only 5 days.
I have had not the benefit of that compilation, but I believe my learned senior is relying upon that new tobacco company case.
Yes.
But my lord, that has been overruled long since, my lord.
That's what I thought.
My lord, may turn to paragraph 17. May I please, my lord? From the aforesaid observations, it is plain and clear that the decision in BK Srinivasan also reiterates that the notification will take effect only when it is published through the customarily recognized official channel, namely the official gazette. We also agree with the reasons recorded in Mayor Hans Judge and hold that the notification under section 25 of the Customs Act would come into force as soon as it is published in the official gazette and no further publication is required. Hence, the decision rendered in Pankaj Jan agencies represents the correct exposition of law on the subject. The decision rendered in New Tobacco Company, the presently cited Miller, followed in so and so, does not lay the correct law. Then thereafter, the Honorable Apex Court held that from the date of publication in the official gazette is the date, my lord, it will take effect.
All right. In view of the decision, authoritative decision of the Supreme Court, you say this revision petition was admitted on 17 July 2009 and the following question is framed for consideration. Then you say, in view of the decision of the Supreme Court of India, in Union of India versus Ganesh Das Bhojraj, 2009 SEC 461, the position is made clear that notification comes into force on the date it is printed in the official gazette and not from the date on which it is made available to the public. The question is accordingly answered in the affirmative by holding that publication of notification in the Orissa Gazette can be made effective from the date of its printing. Full stop. The revision petition is disposed of there.
My lord, the STRV number 498, my lord. My brief has totally been destroyed. I'll just take one day, let it become tomorrow, my lord.
At the request of counsel petitioner. Is it a different point involved?
Yes, my lord.
Yes, my lord, different point. Different point.
Different.
I see. At the request of counsel petitioner who states that he does not have the paperwork list on 23rd June.
Weekly list item 36.
None of these.
36 become infructuous.
Okay. 36, you say counsel informs the court that the petition has been rendered infructuous. It is disposed of as such.
This is against interim order. Read petition is still.
It's all right.
Weekly list item 37.
I have pardon to mention it. My lord, item 37. Here, my lord, the contempt of is pending since long. Kindly see the writ appeal order which is annexed here is para 7, my lord. Para 7 of the writ appeal, which has been violated by the opposite contemptor. That para 7. Now the learned counsel.
AD card. Anyone appearing for the opposite party?
No, my lord. In spite of the notice, they are not appearing.
No.
The order this court.
No. AD has not been received back, sir.
Then when a special messenger may be ordered, then I am repeating that.
Not after 14 years, sir. This is 2008 matter.
Then why not the poor whose
If
husband
you get it
expired?
listed, we listed it on our own. Otherwise, this would not have been listed at all.
Why not? Only 18 in the year 1918, the notice had been issued through.
No steps have been taken. For 14 years, we have not taken any steps.
Repeated file and the notice had been
For
issued.
14 years, no steps have been taken.
Why not one thing that is bypassed?
The notice earlier issued has been returned.
Order of the Honorable Court, a certificate, the tribunal will initiate a certificate with so much
Sent by
of
registered post has not been received back. No steps have been taken for over 14 years now. The court at this stage.
I may be permitted to move before the tribunal to initiate certificate proceeding, my lord.
That we do not. The petitioner.
That is the order of the Honorable Court.
This will not prevent the petitioner from seeking other remedies as may be available to the petitioner in accordance with law.
Weekly list item 38.
Item 38. Your Lordship, your Lordship might have remembered these are the matters. The first matter is that matter pursuant to the order of Honorable Supreme Court in case of William Fernandez. All the cases have been directed to be revived. Your Lordship, the original leads will be revived. And pursuant to the direction of Honorable Supreme Court, all these cases have been revived and all these cases have been fixed on 29th June, Your Lordship. So let these two matters may be listed on 29th of June.
All right, list on 29th.
Weekly list item 39.
Lordships may say with the entire batch, my lords, because there is a complete batch of matters in.
All right, sir.
I don't know why
it won't vanish anywhere. It will be the list only. Yes.
Your Lordship. Obliged.
Weekly item 39.
39, I may be permitted to withdraw.
All right, counsel, the petition to withdraw this appeal, dismisses withdrawn.
My lord, I have, well, in this case, I am appealing for the respondent. My lord.
All right.
I have filed a memo, my lord. You also may, I mean, permitted to make a mention to that.
No need, sir. He's withdrawing the appeal. Yes.
The affidavit which has been sold by the concerned attorney.
He's withdrawing the appeal, sir. What more do you want? Yes.
Well, the person sold affidavit is
we are not passing any further order. If he's saying he's withdrawing the appeal, we are not passing any further orders.
Weekly list item 40.
May I please, my lord? My lord, in terms of the direction of the industrial tribunal, a meeting was held between the management and the union, the opposite party, on 22/6/2015. The directions have been complied with, my lord.
All right.
So
The petitioner states that the directions issued by the industrial tribunal have been complied with. The petitions have been rendered infructuous. The memo enclosing the agreement is taken on record. The petition is disposed of. Petitions are disposed of.
Weekly list item 41.
None appears dismissed or not prosecution.
Weekly list item 42.
None appears dismissed or not prosecution.
Weekly list item number 43.
Plus a case of dismissal and the order of labor court is in challenge. The labor court has reversed the dismissal. So may I play I have to file a written note. Can I?
No. So let's carry on the back.
Okay. Obliged.
May I be pardoned, my lords, item 42. My lords, some problem with the connectivity, my lords. My lords, actually the file has been misplaced. My lords, may give me.
It's all right. Either way, the same thing, sir.
My lords.
You can revive it whenever you.
Kindly give me liberty that if any fresh cause of action.
No. No need for that. Yes.
Millets.
43.
Millets, the workman was up. Second party workman was appointed as bond partner in the year 1976. Millets. And on his own request, he was promoted to post of salesman in 1981. He was suspended on 22/12/2006 on the ground of the 6 grounds: negligent in duty, unauthorized absence, disobedience of orders, misappropriation of funds, dishonesty in employer's business, and insubordination. Then he was asked to give explanation, and he submitted explanation on 9/5/2007. Not satisfied with the explanation, the domestic inquiry was ordered. And Mr. R.K. Satpathy, advocate, was appointed as inquiry officer. And the copy of the inquiry report is at Annexure 3. There's 30 to 72. Then, after a detailed inquiry, there is joint inquiry held, including this workman, two others, negligent workmen. They were also with the permission of the consent of the workmen. The joint inquiry was held, and 3 charges were proved: negligent duty, unauthorized absence, and disobedience of order of the higher authority members. And the misappropriation could not be proved. Misappropriation was proved against another workman. So on 4/8/2008, show cause notice was for punishment of dismissal was served on him at Annexure 4. Then he gave explanation at Annexure 5 on 18/8/2008. And 22/9/2008, the matter was placed before the board. And by order dated 39/2008, he was dismissed from service. It's Annexure 6 minutes. So thereafter, by reference at Annexure 7, the matter was placed before the Labour Court, and the impound order is at Annexure 8, dated 10/6/2011, at page 81 to 91 minutes.
Yes.
The Labour Court framed 3 issues, minutes. Whether domestic inquiry is fair and proper, whether the dismissal dated 39/2008 is justified, and whether the relief for what relief is the workman is entitled to. And whether Labour Court took the first issue as the preliminary issue, and answered accordingly, and answered that the domestic inquiry is fair and proper. Your Lordship, page 85.
Yes.
Point number 7. As per the order dated 18/3/2011, the domestic inquiry conducted by the management is fair and proper. Then, as regards the issue number 2 and 3 as concerned, the Labour Court came to the finding that the first party has failed to prove its case, and held that dismissal is not legal and justified, and therefore the management has challenged that order by this application. So let's see. May press 8, issue number 2, how the page 85, issue number 2, how the Labour Court has answered me.
Yes.
Admittedly, the second party workman, Shishupal Sahu, appointed as a pump attendant in fuel filling station of the first party management in the year 1976. He was promoted to next higher post by order dated 913 dated 1/10/1981. On 22/12/2006, the second party workman was suspended by the first party management. On 39/2008, the second party workman was dismissed by the first party management by letter dated 2/88 dated 39/2008. The first party management framed charges against the second party management alleging for unauthorized absence, disobedience of orders and misappropriation funds, and negligence in duty. The inquiring officer submitted the report that the second party workman during the course of inquiry failed to give the detailed accounts of his shift duty during the year 2004-2005. The management made the allegation against the second party workman that he was negligent in duty. The representative on behalf of the first party management submitted that second party workman.
So what is wrong with the finding? You tell us that.
Wrong, Lords. Admittedly, I found very little time to come through the judgment, Lords, because it has come after 11 years, Lords. But the Labour Court has not, the unauthorized absence was proved. He has admitted he was absent unauthorized. But the Labour Court didn't take into account that his admission, that he was absent. And though misappropriation could not be proved, Lord says, I have taken that ground, Lord.
page 13, page 12, point number 18. Land court below failed to appreciate the conditions of first party management has passed the impugned award in a very casual manner, only referring to the evidence adduced by the workman. Only the evidence of the workman was referred. The evidence adduced on behalf of the management has been brushed aside. Apart from also that allegations proved by the first party management regarding major misconduct which was confirmed by the PO Labour Court during the adjudication of preliminary issue, holding that domestic inquiry of by the management is fair and proper, and being serious allegations have not covered by the presiding officer Labour Court. Next point is also important, Lords. The finding of inquiry officer was accepted by the PO Labour Court where is without giving an order on the quantum of punishment, whether the punishment award as a management is appropriate to guilt or not. The court will have passed the impugned order and turned the dismissal illegal without basing on the recorded evidence of the workman. Workman has admitted he was absent. Lords. Further, the PO Labour Court passed order in spite of the fact that acts proved of the workman is prejudicial to the interest of the organization and the punishment to be proper. The next is that the inquiry report of inquiry officer reported that the second party workman during the course of inquiry failed to give the detailed accounts of his shift during 2004-2005, and the inquiry officer after thorough inquiry came to the conclusion that it is established that dereliction in duty of the part of the second party workman is established. Next, it was the admission of the second party workman before the inquiry officer that management has directed the salesmen of the petrol pump to submit the sales statement and to present retention of sales process, where the second party violated the order of the authority. Hence, the inquiry officer established the charge of willful disobedience of orders of the authority and subordination laws. That the inquiry officer established the charge about the absence of in the filling station from 8 a.m. to 10 a.m. on 1/7/2006 during domestic inquiry, and the second party workmen admitted the fact of absence from 8 a.m. to 10 a.m. on 1/7/2006. But the president of first party during visit detected his absence, which he clearly stated during the domestic inquiry. The inquiry officer further established the charge of insubordination on the statement of second party workman by non-joining the post of stock in charge, insubordination and disobedience of orders. Authority was established by the domestic. He was ordered to join but he didn't.
Who's for the other side, sir? Who's appearing on the other side?
May I please, Your Lordship?
Yes.
I may be permitted, Miller. I may be permitted to appear, Miller. That's consent memo for the workman, Miller. That the finding of the learned tribunal does not suffer from any perversity, because on the contrary, Miller, the learned tribunal has found the inquiry report with perversity. Because there is
no. How do you say this dismissal is proportionate? It's only unauthorized absence.
Absent, that is the explanation the workman has adduced, that at the very same he was deployed it 2 kilometers away by the employer. That is in the record. He has adduced. He was at that point of time he was sent for to another go down by the employer. That's why the disobedience has been negativated at tribunal.
We don't interfere. All right. We pass the detailed order. The petition is dismissed. All right.
Weekly list item 44.
44 minus no instruction. No instructions disposed of.
Weekly list item number 45.
Obliged.
45, my lord. No instruction in the matter, my lord.
No instructions disposed of.
Weekly list item 46.
I am appealing for appeal part number 2, my lord.
Who's for the petitioner?
My lord, I am the petitioner.
Yes.
Well,
the challenge to Orissa constitutional amendment. Also look to the Also look to the prayer. Also look to the prayer.
My lord,
The constitutional.
my lord, let me submit first.
Just a minute.
Schedule class 1950 order.
Yes. Now the central government has not filed the counter.
Oh.
Central government has to file the counter. Central government has filed the counter.
How he's appearing on behalf of private party? How he knows that central government has not filed the counter?
The counter has been filed by opposite party number 2 on behalf of opposite party number 2, so also opposite party number 1. It is written.
Counter copy has been served on me.
Then I am submitting the how central government has filed the counter. The central government has already filed the counter.
Yes, we have filed.
Central government has already filed the counter. Central government has actually filed a time petition in miscellaneous case number 10,383 of 2014, stating that they want time to file the counter on behalf of the opposite party number 1 and 2. Opposite party 1 and 2, opposite party number 1 is central government. Opposite party number 2 is the Registrar General of India. They have taken the time for 6 weeks to file the counter in the year 2013, June. And subsequently, they have filed the counter. On
30th June 2014.
Subsequently, they have filed the counter on 30th June 2014 on behalf of both the opposite parties. Kindly just see the counter filed by the opposite party number 1 and 2, running page 43. At para 2, that I am acquainted with the facts of the case and authorized to swear this affidavit on behalf of other opposite parties. In miscellaneous application, they have mentioned that I am to file on behalf of opposite party number 1 and 2. In para 2, this opposite party is being authorized on behalf of opposite party number 1 has filed this counter affidavit. Since last 5 years or last 9 years, nothing has been stated by central government. At this stage, when it is fixed for final hearing, they want to delay the case. Nothing more.
So central government is not asking for time, sir.
They want to file the counter. They have already filed the counter.
No. Central government is saying we do not want to file any further counter affidavit. The counter affidavit already filed is what we are adopting.
Yes, madam. We have already filed.
The problem is they have not served me a copy because I am appearing for the opposite party number 8.
Oh.
With whom copy? Which copy?
Central government.
That is your internal matter. If another opposite party has not given to opposite parties, then how we are going to be affected?
It is not an internal.
The opposite parties are on one side. If they will tell that he has not given to me for which I want to take time, then it will go on this way. Then one day they will fix that you are required to file the rejoinder. Why you have not filed the rejoinder? That's why another date is to be given.
Anyway, you don't want to file a rejoinder.
I have already filed the rejoinder.
But you have not given a copy to me.
Because they were not party at that point of time when I have filed the rejoinder against central government as well as the state government.
No, central government also says it does not have your rejoinder, sir.
Yes, I don't have that rejoinder. Copy of the rejoinder.
I have already served since last. I have already served it.
No, it was Mr. Satyadhar Das. He was in the ASG. He has not received. It is not there in the file. And there is no noting that rejoinder copy has been served on Mr. the then ASG. It has not been served.
Not been served.
My lord, it is maybe in the record, court record. We have already served the copy. And the court noting is the court noting. And on last all occasions, they have never stated that they have not received any rejoinder.
When was the rejoinder filed, sir?
We have already filed rejoinder since 4 years in the month of December 2018. And it is served on the opposite party state as well as center on the both in the court premises.
Stated to have been filed in December 2018 itself. Copies thereof do not appear to have been served on counsel for the other parties.
State has not received.
Meanwhile, counsel affidavit of opposite parties, opposite party number 2 has also not been served on counsel for the other parties. Today, opposite party number 8 has filed an additional affidavit, copies of which have been served.
I'm serving the copy.
My lord, if they want to take time, then my interim application may be disposed of today. I filed an application to not to give any benefit to this community till decision of this court.
That copy of the petition has also not been served on me.
Everything is not served on. Last occasion it has been served on the court, they are telling. And this is delaying to frustrate the case of the genuine person.
I don't have any intention to delay the matter.
I am not received. It is to what extent they have gone on. Last occasion, when the Chief Justice Javeri was present, telling the same thing, I have not received the copy. I have told that you have received on that occasion in the year 2018. And how he is going to be affected? When he fully supports in my case.
So what is your IA number, sir?
My lord. I there.
You have not even served me copy also.
You are not there.
There is no noting in the list also, I think. I just.
My lord, it is my lord, it is 18,677.
Okay. IA 18677 of 2018. Notice be accepted by the respective counsel for the non-applicants. Copies be served on them to enable them to take
My
instructions.
lord, everybody has received the copy since last 4 years. They're telling him something. It isn't there.
Yeah, yeah.
If this is the we are.
29th June, sir.
Wait,
My lord, on 29th, let it be fixed for final hearing.
My lord, IA number 6614 of 2019. I have filed an application for intervention. That may be allowed.
Who are you, sir?
My lord, I am in support of the petitioner.
No. What's your name? What is your capacity? Why do you want to intervene?
My lord, my name is Dingor Kumbhar.
Who are you?
My caste is Gondo.
Sorry?
My caste is Gondo, who is coming under the scheduled caste list.
Why should you intervene? I don't understand. If you want to file a substantive petition, you file.
Yes.
Not intervention is not the route, sir. What is your number? IA number?
6614 of 2019.
Yeah, 6614 of 2019. Since the interveners want a substantive relief as regards their caste, they should file a separate substantive petition. According to this, IA is not entertained and it is disposed of as such.
My lord, in the case of Palghat Jila Thandan Samudaya Samar Krishna Samiti, there was one person who wanted to be intervened in that case. Honorable Supreme Court has categorically told that you cannot allow to be intervened in this case. If you file a separate thing, and you can argue in this case.
Which is what you just now said, sir.
My lord,
just now said that after the order is passed, you argue the same thing. All right.
Sir, Bag A, my application for implementation, petition of intervention, petition of four.
No intervention, sir. You're not entertaining intervention.
1918.
What is your IA number?
15774 of 2018.
1577 of 2018. For the reason stated, while disposing of IA number 18677 of 2018, this IA is also disposed of accordingly.
Prabhakar Malik.
In place of my lord, in place
all right. 6615.
My lord, in place of Mr. Satyadhar Das, D then ASD, my presence may be rotated so that in future such type of he is saying that he has served copy on me. As a matter of fact,
Name of Sri Bimbisar Das be mentioned in the cost list.
Weekly list, item number 47.
Just show the paper book. I think there's some letter that has come.
all of it. Yes, जबरदस्ती मिसेज और हल्ला दिया
April 2014. This PIL was registered on a letter filed more than 8 years ago regarding the escape of a prisoner from police custody, an under trial prisoner from police custody. Obviously, other events have transpired thereafter, rendering the petition infructuous. It's disposed of as such.
Weekly list item 48.
My lord has disposed of this.
numbers 48, I'm not waiting for BMC, my lord.
All right.
This was a letter which was treated as a SOMO to PIL by the
Mhm.
petitioner. I don't think he's here. It's for construction of a road.
In Rama Sir Lane, is the road now constructed or not constructed? You don't know.
Instructions are not yet. The people had requested for the road to be constructed, but four amongst them have come up.
No, in 8 years they would have known if they've really agreed. See, the present PIL was on the basis of a news item regarding the representation of local inhabitants of Old Town, Bhubaneswar.
Yes, ma'am.
About construction of road work in single quotes Rama Sir Lane. Unquote. The petition has been pending for over 8 years now, for nearly 8 years now. And there should have been other developments which have to be accounted for. Permitting a fresh petition to be filed, if the cause of action survives, the petition is disposed of.
Weekly list item 49.
None appears to say so.
Weekly list item 50.
The note has been perused. The MC case is the correction carried out as indicated. Supplementary. Number 12.
Supplementary list, fresh admission, item number 1.
Student VIT Law School, Chennai. District Council of Culture. Not met for so many years. What is this District Council? You see the locus standi of the petitioner who states that he's a student of law in Chennai. What the happenings in the District Council of Culture in Ganjam is not clear. The court is therefore not inclined to entertain this letter petition. This is disposed of.
Supplementary list, item number 2.
This letter petition received way back in 2016 is based on a news report about the spread of kidney disease in Narsinghpur and Badamba block at Cuttack. It is plain that there should have been many more developments since the sending of this petition in 2016, which have to be accounted for, leaving it open to the petitioner to file a fresh petition. The petition is disposed of.
Supplementary list, item number 3.
None please, this was not a
Supplementary list, item number 4.
Lord, may I brief that after commencement of the RCFC Act 2009, which came into force with effect from 1/4/2010, all the teachers, irrespective of designation, either assistant teacher or headmaster or Ganashikar, they were clubbed together as teacher, and under section 23, it was prescribed that even the existing teachers, those who are not in position of qualifications, upgraded qualifications, they will acquire the same within 3 years. But in pursuance to the enabling provision of section 38, the central government has framed also RCFC rules 2010, and state government has also parameter rules of RCFC rules, that is right of children to free and compulsory education rules 2010.
Dealing with education matters. It will come before that concerned DB, sir. Malad, it has to come before the concerned DB dealing with education matters.
Here I have questioned the correctness and validity of
I know.
conferring
Those concerned
the ex-cadre
DBs
status.
The concerned DBs will deal with those constitutional validity.
Then it will come in single bench, my lord.
No. There's a DB dealing with good question. Or we'll deal with the tasks. Or at notice, who's there for the other side?
I am for the.
Mr. Mahapatra accepts notice for the opposite parties. Reply be filed within 8 weeks, rejoined up to the next day. Well, 22nd August.
Supplementary list item number 5.
Item number 5, my please, Your Lordship. My Lord, in this case, I'm challenging the inaction been done by the opposite party number 3, that is in the SCB Medical College, my Lord. So I have directed a representation to the vigilance. But there has been a particular kind of, in this EBL server, if Your Lordship may have a glance at page 10, my Lord, Annex 2, my Lord. That's where the IBM server, my Lord, they have, I have annexed that. In the year 2014, 15 and 19 till date, my Lord, all the time that IBM server has been granted to a only company. It has never been tendered. And that's what I have queried before the investigation department.
And we made a representation.
Representation, my Lord.
Or
and to the authorities too.
My Lord, that vigilance representation may not be directed to be disposed of because vigilance department there to register the case and investigate. So far as the second representation is concerned, Annex 2, Your Lordship may direct the superintendent to examine the
That's
issue.
what the petitioner's representation dated 12/10/2021 shall be examined by the superintendent, SCB Medical College. Bracket opposite party number 4, and after giving the petitioner hearing, a reasoned order shall be passed thereon not later than 1st August 2022, and a copy thereof be provided to the petitioner not later than 8th August 2022. The court clarifies that not expressed anything in the matter.
My Lord, non-compliance, if I may approach to the vigilance, Your Lordship may just have the.
It will be open as regards the grievance about the vigilance department will be open to the petitioner to seek appropriate remedies in court.
Much up.
Supplementary list item number 6.
May I please, Here, my lord, after the petitioner was assessed under section 143(3), he has paid all the tax. Thereafter, proceeding under section 271(1)(c), the penalty was initiated, and ultimately, penalty order of some 11,60,000 was raised, my lord. So, without challenging, I have filed an waiver application before the PCIT. Now, that having been rejected, I have approached this honorable court, and the writ was pending, my lord. During pendency of the writ application, that Vivad Se Vishwas Act has come, my lord, and I have made an application under that scheme. So, my lord, may I just refer to that act? Lord, may kindly turn to page 34. That act I have annexed.
Vivad Se Vishwas.
Yes, my lord. My lord, may turn to page 38. Section 4. So, under section 4, I have to make an application disclosing all the details, pendency of the case and all. Now, under section 5, next page, my lord, 39. Section 5, the designated authority shall within a period of 15 days from the date of receipt of the declaration by order determine the amount payable by the declarant in accordance with the provisions of this act and grant a certificate. Now, subsection 2, the declarant shall pay the amount determined under section within 15 days. Subsection 3 is important, my lord. Every order passed under subsection 1, and that means issuance of a certificate, determining the amount payable under this act shall be conclusive as to the matter stated therein, and no matter covered by such order shall be reopened. Now, my lord, during pendency of the writ application, I have made that application, that is at page 56, as per section 4 of that act. My lord, may kindly turn to page 56. There, towards the bottom 5th column, I have disclosed about pendency of the writ application before this honorable court. Writ, High Court, I have given the number, my lord. Now, adjudicating this, they have given me the certificate that is page 67, Annexure 10. That certificate as per section 5. Page 68, my lord, they have determined the amount to be payable. If the amount is payable on or before 31st March 2021, it is 2,89,000. If after, then 3,47,000. Next page, my lord, page 69.
They say it's not now covered under the
No, my
Vivad Se
lord,
Vishwas
my lord, may kindly just see. Page 69, I have paid that amount within the due date. And the very next page, page 70, that's the impugned order. Now, after acceptance, that's the conclusive. They have to issue a certificate under section 5.3, that certificate is conclusive. I have paid the amount within the due date.
We just issue notice. It says a notice, Mr. Chimanka accepts notice for the department. For the opposite parties, all of them. Yes. all of
extra
them.
copy can leave.
All right, extra copies be served. The payment made by the petitioner would be subject to the pursuant to the application under the Vivad Se Vishwas scheme will be subject to the outcome of the petition.
It will be
Replies be filed within 8 weeks, rejoined up for the next day. 30th August, 30 August.
Let this matter come along with the pending writ application.
Along with
the pending writ application, WPC 13576 of 2017.
Yes.
13576 of 2017. List along.
Obliged.
Supplementary list for orders item number 7.
May I please, Your Lordship? This is matter related to Sisuvan. Last occasion, Lordship directed to committee to visit the Sisuvan. But unfortunately, on the date we visit, due to heavy rainfall, the visit is incomplete. I pray, my lord, during vacation, we will visit and apprise the Your Lordship after vacation, my lord.
Yes.
During vacation, we will again visit and complete our inspection and give the report to Your Lordship after vacation, my lord. Any date as per Lordship's convenient. Part inspection completed, but due to heavy rain, unable to complete the.
States that some more time may be required to undertake the visit in terms of the previous order. Dated 30th March.
My lord. 30th March, my lord.
2022. At his request, the report of the visit along with photographs were placed on record by the next day. Just on 19 July.
Obliged.
Supplementary list item 8.
But I have no instruction, my lords.
All right. The petitioner states he has no instruction. The petition is disposed of.
Supplementary list item number 9.
9.
Yeah, none appears. They have to make alternative arrangements. No?
And defects are not removed despite 2 repeated orders.
Correct. Defects have also not been removed. Dismissed for non-prosecution.
Supplementary list item number 10.
In my lord, the petitioner challenged the validity of the granted order 2004, my lord. And my lord has similar matter is posted to 28th June. 28th June.
Some matters, my lords, have also disposed of. So here, my lord, the order which has been repealed since 2009, that is under challenge now.
2004 granted order, my lord. In the similar circumstances.
2004, that was repealed on January 2009.
And our institution
7th January 2009.
My lord, the similar matter is, my lord, is posted on 20th June.
No, but how do you justify challenging a repealed order?
Here, my lord, we are eligible to prior to my lord 2004, my. As per the granted 19.
No, that may be, but your challenge has to be then not to the
only validity of the 2004 granted.
It's not even there, sir. It's been repealed now.
My lord,
the order has been repealed.
To that, my lord, I will satisfy my lord.
Yeah, no.
On 20th.
It will be open to the petitioner to withdraw the challenge in the present petition is to grant in aid order of 2004, which stood repealed in 2009 itself, leaving it to the petitioner to file a proper petition in accordance with law. This petition is disposed of.
Supplementary item 11.
May it please the court. It's an application challenging the inaction of the revenue authorities in not taking steps to prevent large-scale encroachment.
We made the encroachers parties You have to make the
No,
encroachers
the
parties.
encroachers are not parties.
Yes. Even in your representation, I think encroachers are not mentioned. Without, you see, but counsel the petitioner seeks leave to withdraw this petition with liberty to file a fresh representation in the first instance before the authorities, naming the encroachers, and after following up on such representation, seek appropriate remedies in accordance with law. Disposed of is withdrawn with liberty is paid for.
Supplementary item 12.
Petitioner filed this case against establishment of a court in a Gochar land. My lord, that land is 70 kilometers from one side and 4 kilometers from other side, my lord. And the local area, only one land depending as a his cat.
You're questioning the establishing of a court.
Yes, my lord. That is not convenient and not
Binjarpur. Where is Binjarpur?
This is of Jajpur. Binjarpur area, my lord.
People want courts, sir, and you are saying no, don't have a court.
My lord, I have given the annexure 6, page 21.
You don't want a court.
One court, my lord.
And
One
then
in middle place.
you have to
my
give
lord.
land for the court, sir.
Land is there is various land in Binjarpur area. That is also in middle place. I have given annexure 6, my lord. Kindly see page 21. From one side is 17 kilometers, another side is 4 kilometers. So local people will face various difficulties.
Normally, courts are established in outskirts, keeping in view the future. After so many years, it will be a crowded area. So, in your lordship can see in all the stations, the courts are in the outskirt areas. So, normally, in due course, people will be acquainted with that.
Correct.
In Binchapur area also there
That
is an
can-
outside also land is there, my lord.
And in Bhadrak also, that this is the same condition. Initially, the lawyers were not accepting it, and later now everybody is happy with this.
Correct.
Alienation case and de-reservation case has been initiated in the year 2019, madam.
Right.
Yes.
2022.
Yeah.
In 2021, last party is demarcated the land. And
But you're waiting for so long, sir.
Thereafter, petition also
You're
filed-
filing it only on 20th April 2022.
Thereafter also petition has filed objection before the collector. my lord.
Annexure 1, page 11.
Yes.
Proceedings have been initiated in the year 2019.
Petitioner's grievance is against
My lord, kindly see the annexure 3, my lord.
a letter issued by the Tahsildar, Binjarpur, District Jashpur, on 7th October 2020. Stating that government land, that sanction for the alienation of government land in favor of the Registrar Civil Courts Jajpur, construction of a civil judge bracket junior division come JMFC court in village Lenka Sahi. Had already been submitted. Paragraph, it appears that public notice was in fact issued and on 15th March 2022. What is this paper publication?
This annexure 3, my lord, lordship may see, and the reference has been given, page 13.
Demarcation.
Public notice has been served by notice dated 5/8/2021. They were asked to remain present for demarcation.
Right. No, what he's enclosed at annexure 5 is the
This is a paper publication.
I see.
The publics are opposed or a paper publication is.
Since the alienation is for the construction of a court, which is much needed for the people of the locality, the court is not inclined to interfere in the matter.
My lord, kindly directed to collector to dispose of my application.
No, sir. The petition is disposed of.
Supplementary list item 13.
May I please, Your Lordship? Your Lordship, the opposite parties are not collecting the paddy even after distributing online tokens, Your Lordship. The farmers are suffering for this, Your Lordship.
Though it's a public interest litigation, Lordship, may kindly see the petitioner himself is a beneficiary. Page 15, my lord.
Yes, Your Lordship. He has declared
Page
that he is one
15.
of.
So then it's not a PIL, sir.
Yes. He
List
himself
before the
is a-
appro- this,
one of
this
the-
is not a PIL since the petitioner himself is a beneficiary of the reliefs being sought. List before the concerned bench, assigned bench on Friday, 20th.
Supplementary list item 14.
Pass over.
Supplementary list item number 15.
Pass over.
Supplementary list item number 16.
Yeah, please, Your Lordship. Here, my lord, this is a public interest litigation, my lord. Filed by the petitioner seeking a direction from the Honorable Court to the OP number 3, my lord. The OP number 3 is collecting the exorbitant fees, my lord, with regard to the enrollment fees, my lord, by the lawyers. My lord. I've given a comparative chart in annexure.
All right, you say notice. Notice, Mr. Party, you accept for one.
Yes, my lord. Yes, my lord. Yes.
Notice be served on the remaining respondents. A registered speed post returnable on the next date. Replies be filed within 4 weeks of service. John Tiffany, 3rd August.
Supplementary list for admission item number 17.
My lord, in item 17, I have filed the affidavit of the health secretary as directed by this honorable court, but I could not serve the copy because I couldn't find it. Just now I am serving the copy. Your lordship may fix it to next after vacation and.
Got it. May I pray, my lord?
Yes, please.
My lord, the additional chief secretary is supposed to file the affidavit not later than 13th May, my lord.
He's handed it over to you, sir.
That only today they are giving, some time may be given. I will examine and if necessary, I will file counter, my lord.
All right.
Matter relates to disposal of biomedical waste, my lord.
The affidavit of the additional chief secretary health has been handed over in court today.
No, my lord, it is already e-filed since long, I think.
All right.
Physical.
You say hard copy of the additional affidavit of the additional chief secretary. Health has been handed over in court today with a copy being provided to counsel the petitioner. He needs some time to address arguments thereon. July. July. 20 July.
My lord,
Orissa.
oblige me.
Supplementary list item number 18.
May I please? Here I am facing a very strong opposition. Here this has been filed by the state. My lord, an industrial dispute was raised alleging violation of section 25F, 25G and 25H of the IDR And while in the impugned award, the Land Labor Court held that there is no violation of Section 25F, but relying upon only on the oral statement of the management witness, came to conclusion that there is violation of Section 25G and 25H of the Industrial Disputes Act. Accordingly, the Land Tribunal directed for reinstatement of the opposite party workmen, 7 workmen. Now, you also may kindly turn to page 18. The paragraph 5, the issues. Issue number 1, whether the termination of services of Sri Kailash Chandra Malik, Sri Pranakrishna Parida, Sri Abdul Kumar Jena, Sri Ramkrishna Behera, Sushanta Jena, Narayan Sethi, and Ganeshwara Baral, all deliberated workers, by of refusal of employment with effect from 21/7/2001 by the veterinary assistant surgeon, Remuna District Baleswar, is legal and justified. If not, what benefits Malik and 6 others are entitled to get? My lord, issue number 1 and 2 were taken up together. You will see kind of next page, page 19. Page 19. No, not page 19. You will also kindly state it, page 22. Page 21 bottom, you will also kindly see. Page 21 bottom. In the above sentence, the management has nowhere used the word notice pay, and therefore I am not able to agree with the contention raised by the workmen that the management has decided to pay terminal benefits within the meaning of Section 25F of the Industrial Disputes Act 1947 to them, as each of them had worked for more than 240 days during the preceding 12 calendar months. The workmen have raised another point that Section 25G and H of the Industrial Disputes Act 1947 was violated by the management. I find force in the aforesaid contention of the workmen. The management has annexed a list of workmen along with the respective date of engagement with the written statement. MW1 has also stated that the date of engagement of each of the workmen during the time of his cross-examination. For better appreciation, I think it will be appropriate to reproduce the same here. From the above table, it is clear that all the workmen of the present case were engaged on some date in the year 1994, 95, or 96. It is admitted by the MW1 that one Ganeshwar Giri, who is still working in the LBW firm, joined on 26/3/97. Thus, it is proved that while the seniors have been terminated, the junior has been retained by the management, violating the principle of last come, first go. MW1 has further admitted that some other persons have been engaged after disengagement of the workmen of the present case to work on daily wage basis whenever required. He has further admitted that the workmen of the present case were never engaged after their disengagement. According to him, the house of the workmen of the present case are situated at a distance, and he had sent intimation to work in the firm, but they did not join. Subsequently, he has admitted that he had not informed the workmen in writing to join in duty after their disengagement. Now you will also see page 24, paragraph 11. The workmen of the present case were engaged as daily wage laborers by the management whenever required. There is no sufficient material to hold that each of the workmen had completed 240 days of work during 12 calendar months from the date of the retrenchment. Therefore, the management was not bound to comply the Section 25F of the Industrial Disputes Act 1947 at the time of their retrenchment. So far as this part of the case is concerned, the action of the management cannot be said to be illegal and unjustified. But according to settled position of law, the management was duty-bound to give an opportunity to the retrenched workmen as it proposed to engage persons as casual laborer, but the management, without giving opportunity to the retrenched workmen, has engaged some outsiders. Also, it is proved that the management has retained a junior while retrenching the workmen of the present case who are senior to him. Since the above action of the management is opposed to law, I would say the same to be legal and unjustified. In the facts and circumstances of the present case, the workmen are entitled to be reinstated in service, but without any backward. Here, no evidence was adduced by any of the workmen who was the junior who was kept in service.
No, this one person was kept. They have actually led evidence for that.
That is only the statement of the management witness.
More than enough, sir. You are the management. The management witness himself says this.
And more so, the workmen also did not.
Why should the workmen have to prove? You yourself are admitting that this Ganeshwar Giri is still working, whereas his seniors have all been asked to leave.
And the other parts for a 25H violation is concerned, but there is not a single witness as to who were the persons engaged, re-engaged, and what are the categories. No evidence was adduced.
All that will be with you, sir.
So that was not before the land tribunal.
No,
And in a similar situation-
basic issue is last come first go, correct?
Yes.
That
So
has
far as
been
25G
violated.
is concerned.
That has been violated.
But
So
so far as
basic relief granted is only reinstatement.
Yes.
And this award was challenged after 2 years. And the law is well settled that if in any of the preceding year, the workman was for 240 days, he deserves a protection under section 25F. The workman should have challenged this award with regard to this part of finding of the learned tribunal. But since they were hopeful that management will implement the award, and they waited for 2 years. After 2 years, the writ was preferred. Award is of the year 2009. The writ was preferred in the year 2011. They were hopeful that they will be reinstated. That's why they forgot the relief with regard to back wages.
Correct.
And I have given.
We are not inclined to interfere, sir. We'll pass the detail.
And relying upon only one judgment, subject to correction by my learned senior, whether it is overruled or not.
I have given a memo of citations, number of judgments with regard to each point. And my London Fred citing a judgment also has taken note of one of my judgments cited, that is AR 96 Supreme Court 2526. And I was examining that judgment. The facts and circumstances of that judgment is different, is on a different footing. Here, in our case, there was an admission with regard to a deviation of 25G, so also 25H by their own witness.
That's right.
And the section 25G says that there can be a deviation with regard to fast come, last go, subject to giving reasonable reasons, sufficient reasons. I may be permitted to place 25G. And the Supreme Court, Honorable Supreme Court has taken note of that wording. That is a specific paragraph. 25G, your Lordship may kindly have a glance. Can I place it? Procedure for retrenchment.
Yes.
Where any workman in an industrial establishment who is a citizen of India is to be retrenched and he belongs to a particular category of workmen in that establishment, in the absence of any agreement between the employer and the workman, in this behalf, the employer shall ordinarily retrench the workman who was the last person to be employed in that category, unless for the reasons to be recorded by the employer, retrenches any other workman.
So here
there is no reason assigned as to why there was a deviation. And your Lordship, I may be permitted to place one, their own document. There was a minutes of meeting before the labor authority that what they should adopt. And they deviated that, illegally retrenched us without any retrenchment.
Anyway, sir, we are not allowing we are dismissing the petition.
Only
the detailed order will be passed.
Only paragraph 28 of the judgment.
We'll look into it.
And your Lordship, so far as your Lordship's direction for compliance of 17B, they have complied till January. So may I pray while passing appropriate order?
From January to April.
Yes.
All right.
From February to April.
All right.
Okay.
Supplementary list item number 19.
Item 19, in compliance of order dated 6/12/2021, I have received the compliance affidavit, but it's only one copy. In course of the day, I will file it.
Mr. Murali states that compliance affidavit will be filed during the course of the day. This 21st July.
Supplementary list item number 20.
May I please, madam? Last occasion, my director, my friend,
Yes, madam.
filed an affidavit about the
May I pray,
underpass.
madam? I need some more
Puri Road
time.
underpass.
Yes,
School is there.
I need some more time to examine the feasibility of construction
Mr.
of
Das
underpass.
states that some more time is needed to examine the feasibility of providing an underpass. At his request. List on 21st July. Sir.
Supplementary list item number 22.
Wait, please, Your Lordship. My lords, this is an application for the interest of disabled students, my lords. My lords, for upgradation of school even after the implementation of Right to Education Act, my lords. My lords, the answer, all the questions I have raised have been answered by the state in the counter affidavit where they have admitted, my lords. In the last occasion, Your Lordship had directed my landlord senior to take instruction that what action has been taken pursuant to the letter dated 2/3/2017, where they have stated that they are doing it. But my
Yes.
instruction is as of now, nothing has been done.
I have received this instruction.
You have to give him copy, sir. Being processed will be shifted. Sir, nothing's really happening.
No, you Lordship, can see the last line. Well, besides the two numbers of special schools running under Bodhita Vikasa Samiti will be shifted to newly constructed integrated infrastructure.
When?
Well,
No timeline, nothing, sir.
Soon. That is, I have.
Even that earlier part proposal is being processed.
So that letter we have issued. Well, what I have telephonically been instructed that within a period of 1 month or less than that, this school will be shifted. Both
Mr. Moduli states as far as shifting of the school is concerned, his instructions are that it will take place within a month. What about upgradation?
Well, once it is shifted thereafter.
No. What about upgradation? That's a separate issue, sir. As regards the proposal for upgradation of the school for the deaf, Novapada, he states that he'll file an affidavit before the next date, indicating the exact timeline for action. 20th July, 20 July.
I'm obliged.
My appearance for OP number 3 may be taken.
All right.
Supplementary list item number 23.
May I please, Your Lordship? My lords, I have filed one reply to the reply of the petitioners on the.
How many affidavits, sir? This will have to stop.
My lords,
Non-stop
my lords,
affidavits.
may kindly see the photographs in the reply to today I have filed, my lords. My lords, they have not complied with any one of the guidelines of the PCCF, my lords.
It started as condition of the road.
Road condition is on the first occasion, as my lord has directed to make the road motorable. They have passed the roads, my lord. But after a
See
few
page 11 and 12.
Your lordship's overall instruction, I have already instructed the project director to have a drone camera video recording and show to my lord by next date because of due to cyclone.
Just see 11 to 16.
But the road is now is a motorable condition. Yesterday I have filed a.
No, just see 11 to 16, the photographs. When were these photographs taken? 10 to 16. When were these photographs taken?
My lords, that photograph was taken in last 3 days back, and I have taken the photographs myself, my lords. In my phone, I have taken, my lords.
I can say that, my lord, there is no
Mr.
date.
Samal
nothing.
has taken
Yes, my lords, I have taken of my own.
a further
It's not
affidavit
the photograph supplied
on
by
behalf
the
of the
petitioners, my lords.
petitioners enclosing photographs which he states were taken
My
only
lords,
3
at
days ago.
Pipilia, the road is not complete, and some bridges are
He
not
insists
complete
that
at
the
all.
road is still not complete in many patches and it is still not motorable. This
And
is
my lord,
disputed by
hold on,
Mr.
hold on,
Nisi
hold on, hold
Mohanty,
on.
learned
Wait,
counsel
my lord,
appearing for the NHAI. He states that he will present a video clip
My lord.
of these very stretches to show that the road is in a perfectly motorable condition. All right.
My lords, something more, my lords. My lords, there is a gross violation of the Rule 8, my lords.
We'll come to that, sir. We'll come to that. The
My
toll.
lord, just-
About that
just
toll.
I want to.
About that toll.
Yes, my lord. About the toll, my lords.
First, let the road get repaired.
My lords, they have not completed the roads. In the counter affidavit, they have said that 87% of the road is complete, which is not true, my lord. They have
28 June.
illegally-
28 June.
My lords, illegally they are just collecting the tolls, my lord.
All right.
It's,
We'll keep it- we're
it's
keeping it in
cutting the
June
pockets
itself,
of the
sir.
poor people, my lords.
Keeping it in June itself. 28 June.
Supplemental list for admission item number 24.
May please.
The two interim applications, flag A and B respectively, my lords.
The B is for condonation of delay. How much is delay?
There's 35 days delay, my
All
lords.
right, delay is condoned, and A is for
dispensing with.
Okay, that's dispensed with. All right,
And the questions of law, my lord, is at page 9, my lords.
not yet framed.
Not yet framed. my lords.
All right. Who's for the other side?
Mr. Mahapatra was appearing, and his name, I think, appears also in the list. Maybe. So I was only praying your lordship would permit me to request your lordship to frame questions on Roman 2, 3, and 4, my lord, at page 10.
It's all the same. It's about depreciation and the vehicle.
My lords, because 2, 3 are slightly different from 4, my lords. So if all these 3, my lords, are subject to your lordship's kind consideration.
All right. Admit the following questions are framed for consideration 2, 3, and 4 from page 10. List of final hearing on 14th September.
Sorry?
14th September.
Greatly obliged.
Supplementary list for hearing item 25.
Open it. Point 5. So only got 0.5 more. You don't make it 1.5. Yeah. He's got 1 mark in one question, but the other question has got only 0.5.
So
He's not made it.
Mela,
He doesn't make it.
1.5, I am entitled to.
No,
because only less than 1, only 0.5, 0.5.
He's getting 1 and 0.5. So he'll get 1.5.
1.5.
So that reevaluation is 45.5. 45.5 plus
1.5.
no, plus 0.5 only, no?
Yes.
Net effect is 0.5.
Yes.
But
But
so he
my-
gets only 46. He has to get 47.
Yes.
So he doesn't make it. He doesn't make
My lord, my lord, how it could be?
it. How can it be? Means we have a
My
law
lord, I have
expert.
answered. My
He's
lord,
given very detailed. Maybe you can give
My-
her a copy of this. This can be given. This. Correct. Very detailed. The law expert has given a very detailed report. If you
my
want,
lord, your
you
lordship
can
may-
get a copy of this. But there's no question of again rejoinder, arguing, and all.
No. I am not that because it will not serve any purpose. That is fine. My lord. I am not there. But my submission only, I can make a submission before your lordship is there.
Yes.
My lord, out of 5, giving correct answer, how can I get 1?
That is why you're very detailed. It's not correct answer. In that citation is wrong. The second part also, the very detailed explanations given. What you think to be correct answer is not correct. So you can go through it.
Maybe. Your
You
lordship
can
may-
go through it. We will not further go into the matter. All right.
Yes.
You say the law expert has submitted a detailed report to the court on the re-evaluation. Full stop. As far as the answer to question 1 in Group D is concerned, the result of the revaluation of the expertise is under A to A. As far as question 3 in Group D is concerned, the result of evaluation is as under B to B. Paragraph. The net result is that the candidate gets just 0.5 marks additional for the answer to question 1 of Group D. Full stop. In all, therefore, the petitioner secures 45 plus 5, no, 45.5 plus 0.5. That is 46%. Full stop. Since he doesn't secure 47% in paper 3, there is no scope for calling him for interview. Full stop. Paragraph. A copy of the re-evaluation report be furnished to counsel for the petitioner. Full stop. That view of the matter, no further directions can be issued in the matter. The writ petition is dismissed.
Obliged.
All right. The answer sheets to be put back in a seal cover and kept with the examination branch. Right.
I beg pardon, my lord. I'm sorry, my lord. I was
along with the re-evaluation report.
I beg pardon, my lord. In item number 24, I was not there, my lord. For the department, I am appearing, my lord.
All right. All right.
There is a passover item 40.
I don't need to make a prayer, Lord, that my miscase for stay may lie over. Item 24 minutes.
Yes, yes. We have not said anything.
Supplementary passed over matter, item number 14.
This is all corruption matter, and your lordship is disposing of by directing the go to Lokayut, etc. Similar type of allegations. Or your lordship will fix it to any other date.
Yeah, no, none appears despite a Passover. Defects be cured in the interest of justice. List on. No, you say none appears despite a Passover. In the interest of justice, list on 20th June, opening day. Meanwhile, defects be cured.
Supplementary list item number 15.
The same order. Same order. Two o'clock, man.
Been
Numbered, is it? Okay. What is it about, Mr. Sinha?
It is, it is about appointment of paramedical workers, because those the paramedic in this Orissa there are 314 community blocks and 90 municipality areas in 30 districts, but there are only 45 trained paramedical workers. So we have filed that there should that some workers should be appointed.
All right. I think the government, if you can serve a copy of your application.
Copy I have served to all.
Copy has not been served up.
Okay. One copy.
Copy number 4 and 5.
I'll just serve.
Then they can have instructions. That's why. Since this is not adversarial.
Please, my lord.
They can give us a timeline within which they will appoint paramedical workers.
Yes. Please, my lords. So, my lords, if they appoint my lords, it's great, my lords. I think my cause will be satisfied. My lords.
Correct. So normally they're not adversarial on these issues.
Please, my lords.
So you just give them a copy of the application. They can seek instructions. What's the number of the IA?
Application number
6754. 6754 of 2022. You say this is an. Can you tell me the organization which has filed the intervention?
Satyanarayan Kushta Samiti. What is the Bikari Makuda?
Satyanarayan Kushta Samiti.
Read out. Say loud. Bikari Makuda has filed it. Satyanarayan Kushta Seva Samiti.
Chief Secretary.
Secretary, General Secretary, Manoj, I can't pronounce the name. Kerry Mahakuda, Satyanarayan.
Just give us a copy of it. I think he's giving it. Yeah. This is an application by the Satyanarayan Kushta Seva Samiti, Puri, asking to be permitted to intervene in the present petition and file written submissions. Stop. Inter alia, the prayer is also that paramedical workers should be appointed against all the 404 posts. According to Mr. Sinha, learned counsel for the intervener. As at present, only 60. How many are working?
45.
Only 45 PMWs are in place. An advance copy, a copy of the application be served on Mr. P.K. Mudali.
I have received.
Has been served on Mr. P.K. Mudali.
I open 4 and 5. Open number 4 and 4 and 6, my lord. 4 and 6.
As well as the DGHS, represented by Mr.
Bhavan Shankar Raiguru, CGs.
Mr. Bhavani Shankar Raiguru,
CGs.
advocate. Full stop. Both of them seek time for instructions. So whenever we take up the matter next, we'll take up this also.
Please, Manoj.
My lords, on the last occasion, we had given a spiral bound volume with 3 schemes of the state. And the essence of the order, if my lord would see order number 27 dated 23/2/2022, the essence of the order was for them to implement the schemes in their own scheme in 12 districts. Now, if my lord would see in paragraph 4 of the order, 9 additional districts were identified.
1 minute, please. The last order is
that is order number 27 dated 23rd February 2022.
Correct.
So in para 4, my lord was pleased to identify 9 additional colonies, and the health secretary was present. He also agreed to that suggestion. Now, if my lord would see paragraphs 4 and 5. Now, so far as these 9 colonies, additional colonies, simply no work has been done. Nothing. All 3 of us would say with some responsibility, they have not done anything. Now, if my lord would see, the directions were very pointed in para 5. There were 5 directions in all. Now, the affidavits which have been filed today, if my lord would see, there are 2 affidavits, one by the health department and the other one by the SSEPD department.
So, can I take up the affidavit filed by the SSEPD department?
My lord.
Yes.
Now, if my lords would see, the SSCP department, my lords, simply mentions in page 4, they have missed out two important colonies, that is Puri and Baleswar, for some reason, page 4. And then my lords may see the steps taken, my lords. Those would begin from page 7 onwards, annexure A. Now there, the state schemes are quite exhaustive. If we had given them copies also. Now page 9 onwards, they simply list out, these are the reports in terms of my lord's order. These are the reports which they have given. Name of the colony, supply aids and so and so. There's nothing regarding rehabilitation, nothing regarding any of how those three schemes are being implemented.
But do they contact you because you are supposed to be part of the?
No, not here. That's in the jail.
No. Here, in this, they don't contact you at all.
No. In fact, that's what I was proposing. Both my colleagues, like that jail matter, my lord, may constitute a team to just monitor this. And maybe two of my colleagues can be present. This is not happening, my lords, at the ground level. The schemes are there. They just have to implement it.
Right.
Page 16 of the same affidavit, your lordship.
16?
Yes, 16. And that is which are the benefits given to the beneficiaries.
No, but we don't even know who they are and what is this. When it was given, nothing is there. And you go to the colony, you'll find people with not having got any of these benefits. So this mere numbers is not serving the purpose.
Now, this scheme...
That's why visiting to the colonies was very important. So what did they do when they visited? That's not clear. The affidavit says they visited.
They ought to have reflected this beneficiary of these 4 names which have been provided house under the rural housing scheme. Although names should have been there.
Now, see, this is a vague paragraph that in compliance to the directions, it is submitted that 11 leprosy colonies were visited by the concerned subcommittees and eligible beneficiaries were identified to be covered.
Now, my lords, for the benefit of the state council, let this, if my lords can just have a look at this scheme in the spiral bound volume, which we had given. We had also shared it with them. Now, page 1 of that compilation, there are exhaustive measures for rehabilitation. And this was the tenor of the entire order. Page 1, my lord may see the objectives. Equal opportunities, promote voluntary action, rehabilitation of cured leprosy persons. Then next, my lords may kindly see, in Baleswar, they have done a wonderful job vis-a-vis this.
Okay.
But these 9 additional districts, nothing, 9 additional colonies, nothing.
And they've left out Puri and Baleshwar.
Puri and Baleshwar has been left out from this, but Baleshwar collector has filed an affidavit. He has done a good job in the meanwhile.
Puri also separate affidavit has been filed.
So, my lords, this scheme of theirs is quite exhaustive. Simply, if they implement this, many of the things would be done. Basically, we want these people to be self-sufficient, and the scheme provides for that. Now, all that they speak of is paying 5,000 rupees to their bank accounts. I have given a convenience note also for today.
That's what I'm just seeing that.
And the health department affidavit is also there. There also it's...
No, I think missed out Puri and Baleshwar because separate affidavits are being filed.
No, the SSCPD was supposed to actually have this thing done for the entire setup.
Correct.
Lord, may I bring to Lordship's notice? Lordship, may kindly see the order number 26.
Yes.
Order number 26.
Yes.
That is dated 30th 11/2021.
Yes.
Lords may kindly come to my lord 16, paragraph 16, my lord.
Yes. The court would want to
The
ascertain.
court would want to ascertain the views of the state government of Orissa on
I have
adopting.
not filed affidavit because this order was corrected on the last date. And to reply to the response to para 16, I have not filed. I will file.
This is extremely important, my lord. On adopting the best practices of the state of Maharashtra in drawing up a scheme for the welfare of persons with leprosy or cured of it, affidavit in this regard be filed for the next date, but both by the Secretary, Health and Family Welfare Department as well as the Principal Secretary, SSCPD Department.
So 3 months in this last 3 months, we have almost lost.
So there are two affidavits of the.
One by the SSCPD department
and one by the Additional Chief Secretary.
And 3 by 3 different collectors. Collector Khurda, Collector Baleswar and Collector Puri.
And if my lords would see the health department affidavit. There also the same tenor of being very vague. Let me see.
In fact, all these directions in paragraph 5 were to be complied by the SSCPT department. But that is why they have filed this comprehensive affidavit.
No, my lord, there's a simply, I believe there's a lack of sensitivity here. My lord may see page 12. Page 12 of that health affidavit.
Page 12 of the?
Of that health department affidavit. It's a table for Cuttack.
Correct.
Now, my lord may see the second table, line listing of cured leprosy persons. Now, number of CLP as per available data from 1/4/2009. So they are relying on data which is 12, 13 years back.
Right.
Now, even we take this, suppose if we accept this also, my lord may see total people are 2,346 and the number of the MCR footwear, that's the basic, they have given 360. This is all this after the court's intervention in the other districts.
No,
they don't segregate between MCR1 and MCR2.
So we don't even know if the CLP figures are correct.
Yes, my lord. So they are filing an affidavit before the High Court. It's a court monitored matter.
That's right. It's very casual. It's very casual.
This goes on, my lords. My lord may see thereafter page 14. For Jajpur, my lord may see the nature of report that they have given. Now, what I was suggesting, my lord, like the jail thing, my lord may constitute an SIT with this SSCPD, the health, and some of us. That otherwise this thing, this is falling by the wayside, my lord.
Correct. And what about the other affidavits?
Baleswar, they have done a very good job, except the houses are not complete. Rest, everything is very good. In fact, if my lord would see, they have done a lot of this skill development activity.
Page 2, your lords.
This is where that Louis colony is.
Yes.
Louis leprosy.
Louis leprosy. This was supposed to be the model colony, my lords. Here, of course, I must say that they have done a good job. If they can replicate this, it's well and good, but I don't know what's happening in the other districts.
And what about Puri and Khurda?
Puri, your lordship, there is an affidavit on record. I give the specific direction to actually find out about the status of the land. And they say that the particular land today is being used for all the festivals.
Rites and rituals of the Loknath Dev BJ.
Yes, festivals and all that. And they say, of course, there is a note in the ROR saying Kushta Ashram, but it's really not recorded in the name of the Kushta Ashram. But then there is no recommendation in this affidavit.
Where else they can?
Yes, and we in fact had find out that there are places around that, and which the collector should take up urgently. So actually, what I find is, and also the other affidavits also, we've been noticing that they're only statistics. And the compliance of the scheme is, I disburse this much of money and that much of money. But again, money loses its value over time. And if they don't have anything, they're going to exhaust that for other purposes. So what's not in place, or the view which is not in place, is we are wanting them to set up a life.
Correct.
which requires a continuous dialogue, not on an ad hoc basis.
Correct.
That you gave this much of money and your work is done. No, these are people who, even if given everything, cannot access the system. So that's I think if that change of perspective happens, then I think this scheme will also be implemented in the correct way.
There are in this area not enough civil society organizations working, or
no, not on this. I have been doing a lot of search and I've been giving calls to a lot of people, but somehow
they will be useful in actually implementing these schemes. If the government was so minded, they could have involved
Missionaries
them.
of charities, they had their setup, but they are probably gradually waning away. We don't know the reasons, but maybe COVID or whatever. But wherever we went, we are not able to find them.
And Khurda, what about Khurda? Affidavit of Collector Khurda?
Collector Khurda, my lord, has filed an affidavit. His affidavit, my lord, he states that some of the steps he is taking, my lord, with regard to supply of wheelchair, providing them the pre-matric, post-matric scholarships, and some skill development programs are going on, my lord.
Just to intervene, the skill development portion is seen at page 9. They've kind of just identified two people, Minu Behera and Satyanarayan Mahandi. 20 and 20. What is that skill development? What is really being given? I mean, it's...
They are writing that the principal special ITI journey on dated 26/4/2022 assured to provide skill development training to CLPs by inviting application from the CLPs during the June-July 2022.
Yes, but
it has not started it.
And it's vague also. What is that you're intending? Because they can't take up anything which is going to hurt their skin. Their skin loses its sensitivity, never comes back.
Okay.
That is something.
No, what about the Khurda? That's what you're reading, right? The Jackie.
Yes, my lord. Lords may kindly come to page 9.
9, right.
The skill development programs, my lord.
Right. So we don't know what skill has been provided.
Same is also page 10 community awareness program.
No, even the self-employment kit, page 10. No such eligible CLP has been identified for self-employment training during the survey of the 4 leprosy colonies. This is something we are not ready to see.
You say, pursuant to the directions issued by this court on 23rd February 2022, 30th November 2021 and 23rd February 2022, affidavits have been filed by, and below that you put 1.
One thing, may I just...
Yeah.
Your Lordship, there's one thing which I feel which is very important. When any person who's living in this position, if some group of people land up, you're here to give you this scheme, that, they don't grasp it.
Correct.
What is required is a counseling. See, you can do it. Please do this. There's a complete detachment in the entire.
It's not like walking into a supermarket and putting it on the shelf and saying you now pick up what you want. Yeah.
They have not come to that consciousness level.
Correct.
You have to bring them there.
Correct.
So that is not happening.
Correct. And they must have confidence in that this will work for them. Yeah.
Exactly.
1, you say, by the Additional Secretary to the Government, Social Security and Empowerment of Persons with Disabilities Department, bracket SS and EPD, bracket. Dash, you say 14th May 2022. Then you say 2, by the Additional Chief Secretary to the Government, Health and Family Welfare Department, HFW Department, bracket. in bracket to say 13th May 2022. Collector and District Magistrate Khurda, bracket 13th May 2022. Collector and District Magistrate Baleshwar, bracket 13th May 2022. And last is fifth is Collector and District Magistrate Puri, bracket 16th May 2022. Paragraph. The amicus curiae has also placed a convenience note for today's hearing. Paragraph. The court has perused the above affidavits. Full stop. While the affidavit of the SSEPD department states that subcommittees constituted by the technical committee visited 11 colonies, bracket excluding the colonies in Puri and Baleshwar. It simply states that, open quotation, eligible beneficiaries were identified to be covered under the resolution dated 23rd February 2021 in the stipulated timeline. Full stop. The affidavit has enclosed certain documents which purports to give the numbers of beneficiaries who have received assistance. Full stop. However, Mr. Gautam Mishra, learned senior counsel, amicus curiae, bracket AC, points out that there is actually no change in the ground as far as the aforementioned 11 colonies is concerned. Full stop. The details of the three schemes floated, that is, the resolution dated 23rd February 2021 of the SSEPD department, 2, the guidelines of the Bhima Boy Bhinakshema Samarthya Abhiyan, and 3, the guidelines on Sahaya, have not been actually examined to see how much of those schemes have benefited the persons identified by the subcommittees. Full stop. Paragraph as regards the affidavit of the Additional Chief Secretary Health, it does not appear to be in terms of the order passed by this court on 23rd February 2022. So the data provided for Cuttack shows 2346 leprosy cured persons. That is CLP, no? They say, yes, bracket CLP. And that of these, only 360 were provided MCR footwear. So, however, the figures themselves seem to be on the basis of data dating back to 2009 and not the latest data. It is a mystery why reference is still being made to 2009 data in 2022. Full stop. It is not clear to the court how many beneficiaries have actually been granted these benefits. Full stop. It should be possible for the names of these beneficiaries to be made available and the kind of benefit given to each of them. Paragraph. Turning to the central point being made by the AC, the number of directions issued by this court, following the directions issued by the Supreme Court in Pankaj Sinha versus Union of India, 2018, SEC Online, SC 1502, would require actual monitoring on periodic basis of the benefits extended to the persons in these colonies, including their daily needs for care and treatment, skill development, rehabilitation, and so on and so forth. A concerted effort will have to be made to sensitize the inmates to the possibilities that these three schemes offer. As pointed out by the amicus curiae, the inmates will have to be single quotes counseled, unquote, as to which schemes would be most beneficial given their peculiar situation. So all this will require a concerted effort made by the subcommittees constituted by the technical committee during their visits to these homes. Paragraph, the court considers it appropriate to direct that a monitoring committee be set up by the SSEPD department, with its commissioner cum secretary being the convener of such committee, having the membership of the Health and Family Welfare Department, and who else should be in this? The collectors.
The collectors of
the concerned
districts.
11 plus 2 districts.
Yes. No, it's 11.
Puri and Baleshwar?
No. Colonies are 11. Districts are, I think, 5 or 6.
Collectors of the concerned districts where these 13 colonies are being monitored.
My lord, district social security officer has to be also a party. My lord, he has to be a member of that committee.
And the district social security officer of the concerned district. But stop, the two amicus curiae assisting this court, namely Shri B.P. Tripathi and Ms. Pamirath, will also be part of the monitoring committee. This is to facilitate implementation of the directions of this court in their true spirit, and to ensure that there is tangible improvement in the conditions in the colonies. Paragraph. The monitoring committee be notified by a separate order of the SSPED not later than 31st May 2022. Paragraph. The court has also perused the affidavits of the collector and district magistrate for the which interior indicates that in the 4 colonies, namely the Bapuji colony, Dharavati colony, the Jagannath Kushta colony, and Ramakrishna Palli colony, there are in all 576 residents and 189 families, and the total number of CLPs are 129. Full stop. Is there any comment on the Khurda affidavit that you've made here? No.
No, Khurda,
Yes, sir. We have made, my lord, may kindly come, my lord, to page 9
of that affidavit.
My lord.
Yes, yes.
Page 9, bottom.
The affidavit mentions two persons, one each in the Jagannath leprosy colony and Ramakrishna Palli colony, as having been identified for skill development training. However, it is not clear why others have not been identified apart from these two. Likewise, this doubts the statement made that there was no eligible CLP identified for self-employment training. Stop. A more concerted effort will perhaps have to be made by speaking to individual inmates, sensitizing them about the schemes and the opportunities available, and encouraging them to opt for one or more of the schemes to improve their status in life. Full stop. The affidavits are silent on all this medical needs and all that, right?
Nothing is done.
The affidavit of the paragraph, the affidavit of the Collector Baleshwar presents a positive picture of development taking place at the leprosy house at Lewis Road, Bampada. Stop. In fact, this could form the model for other districts to follow. Stop. Although substantial work has taken place, there is, from the photographs annexed, still more work to be done. Lastly, turning to the affidavit of the Collector and District Magistrate Puri, it is inter alia stated that the land recorded in Annabadi, bracket Khata number 148, and Sarakari, bracket Khata number 149 of the Loknath Ghat Mauza, with notes in remark column reading open quotation Kushta Ashram, unquote, is stated to be used for open quotation different public purposes, i.e. to observe different rites and rituals of Loknath Dev Vijay Puri in different festivals, unquote. The affidavit is all silent on where else land can be found for having a proper colony for the CLPs.
On the Sanjay leprosy colony, which is
No, where else you can have a proper colony? It's silent on that, right?
silent on. Yes.
The Collector Puri will identify suitable land where a new colony for the CLPs can be established with all modern facilities. Paragraph.
Two more things.
Urges that the technical subcommittees of the technical committee undertake periodic visits in the next 2 months, that is June and July 2022, so that there can be tangible improvements in the colonies identified, in the 13 colonies that have been identified. The colonies that we've identified is 13, right?
Yes, ma'am. 13. One line, my lord, since initially let this committee meet twice, at least twice.
Yeah, the monitoring committee will meet at least twice in June and twice in July for this purpose.
And rainy season, I think we have 20 days left. So Baleshwar work should speed up.
The work in Baleshwar should
Regarding
be
construction.
speeded up to ensure its completion before the onset of monsoon. Right.
May I also bring to Lordship's notice, my lord, the order number 26, that para 16, that the court would want to ascertain.
With regard to the directions issued in para 16 of the court's order dated 30th November 2021, Mr. P.K. Mudali, learned AGA, states that a separate affidavit will be filed before the next date. We'll have it early in August. 4th August. All right.
We are grateful.
All right. All right.
Yes, Milord, I'll be there.
All right. All right.